Hello, I'm Barrister Daniel Barnett. We live in a world where social media is everywhere. We spend so much of our time on Facebook, on Twitter, on TikTok, and social messaging apps such as Messenger or WhatsApp are the way that many of us communicate predominantly with the outside world, particularly for those of us who are or have been locked down during the global pandemic. But despite being able to hide behind a username online, many of our actions on messaging apps do have ramifications in the real world. Many people don't realise that there can sometimes be criminal consequences also. Can I be arrested for something I've put on Facebook or Twitter? Well, the short answer is yes. I'm going to go through a list of different offences that people can commit when posting on social media. It's not an exhaustive list, but it'll give you a pretty good indication of the sorts of offences that you could be prosecuted and convicted for. There are specific offences relating to behaviour and speech online. Section 127 of the Communications Act 2003 says the following. A person is guilty of an offence if he sends by means of a public electronic communication network a message or other matter that's grossly offensive or of an indecent, obscene or menacing character, or causes any such message or matter to be sent. A person is guilty of an offence if for the purpose of causing annoyance, inconvenience or needless anxiety to another, he sends by means of a public electronic communications network a message that he knows to be false, causes such a message to be sent, or persistently makes use of a public electronic communications network. Now, this creates two different offences. First of all, the offence in section 127, subsection 1, which is where a person has sent a message or made a post that's grossly offensive or of an indecent, obscene or menacing character. It also includes where a person causes that message or post to be made, even if they didn't directly type them and click send. And then there's the second section, section 127.2, which is where a person knowingly sends a false or untruthful message or post for the specific purpose of causing annoyance, inconvenience, or needless anxiety to another. It can also cover where a person persistently makes use of a public electronic communications network. This could, for example, cover repeated nuisance calls to the 999 service. The meaning of grossly offensive is set out in a case called DPP, Director of Public Prosecutions, and Collins. And that case holds that the meaning of grossly offensive is whether reasonable persons in a multiracial society would find the message grossly offensive. Slightly circular definition there. A person who sends the message must intend their words to be offensive to whoever they relate to, or at least should be aware they might be taken to be offensive. This can be proved by the content and tone of the message. Use of racial slurs will always be covered within this definition, and this is the section that's most commonly used to prosecute people for hate speech online. According to the DPP and Collins case, it doesn't matter whether the message sent was actually received or seen by the recipient, and it also doesn't matter whether they were actually offended by it or whether the words just had the intent and potential to be offensive. The fact that the message was sent is what constitutes the criminal offence, and the fact that the words were objectively grossly offensive is enough. What's meant by menacing character? Again, it's all about the context. The case law says that the person being prosecuted has to intend that what they're saying online would cause fear or apprehension in any reasonable member of the public who reads or sees it. This basically means that tweets or messages that are intended as jokes aren't covered by this section. That was most famously seen in a very well-known case called Chambers against DPP, where a man tweeted a joke about blowing up Nottingham Airport, Robin Hood Airport. He was convicted, but eventually the appeal court said that the tweet objectively was not menacing in character. Any message or other matter which can include a social media post which is sent via social media is generally going to be covered. The phrase electronic communications network is defined in section 32 subsection 1 of the Communications Act 2003, but it's a very dull definition, and if you want to look at it separately, look it up on Google. But what's covered will include any sorts of messages, including texts, WhatsApp messages, Facebook messages, etc., tweets, voicemails, YouTube videos. And by the way, if you like this video, please click the like button. It helps the YouTube algorithm pick up this video and means it'll be fed to more people who are looking for similar information. So please do click like if you find this video useful. And it also covers many more digital and online posts. A person who commits an offence under section 127 can be subject to an unlimited fine or to up to 6 months in prison. It can only be tried in the magistrates' court. Crown courts don't have jurisdiction to hear this offence. And it's important to remember that not all nasty or offensive or upsetting language is actually illegal. Freedom of expression is a human right. It's there in the European Convention on Human Rights, which is not affected by Brexit. It's Article 10, and the courts have to conduct a balancing exercise between the right to free speech and the right to be free from hateful or malicious communications. The Crown Prosecution Service, who decide whether to prosecute or not, have very clear and careful guidelines on what sort of communications, what sort of posts should be prosecuted, and in the notes below you will see a link to the CPS guidance on this if you want to look into it in a little more detail. There is another offence which is similar to the ones we've just been talking about. It's under a slightly older piece of legislation. It's the Malicious Communications Act 1998, and Section 1 of that Act provides a person who sends to another person a letter, electronic communication or article of any description which conveys a message which is indecent or grossly offensive, which is a threat, or which is information which is false and known or believed to be false by the sender, or sends any article or electronic communication which is in whole or part of an indecent or grossly offensive nature, is guilty of an offence if their purpose in sending it is that it should cause distress or anxiety to the recipient of the message. Threats aren't prohibited per se. It's a reasonable defence under Section 1, subsection 2 of the Malicious Communications Act if you are sending a threat in order to reinforce a demand on reasonable grounds. So if I were to write a letter to you or send you an email saying, if you don't pay your rent, I'll send the bailiffs round, or if you don't pay the money you owe me, I'm going to issue court proceedings, that would be a reasonable excuse, and it wouldn't therefore be a criminal malicious communication under Section 1. Unlike the communication networks offences, which we were talking about earlier, this can be tried not just in the Magistrates' Court, where there's a cap of 6 months in prison or a fine, but also in the Crown Court, where the sentencing powers for the Crown Court can result in a longer prison sentence. That's unusual, though, in all but the most serious of cases. Thank you for watching this video. If you found it helpful, as I mentioned before, please do click the like button. It does help people discover this video and helps this YouTube channel grow. Thank you so much for watching. Do check out some of my other videos. I have them on criminal law, family law, employment law, and we're expanding into a lot of other areas of law in these explainer videos on English law. Thank you so much for watching. I'm Barrister Daniel Barnett. Bye-bye.